From the 1st of May 2026, one of the most powerful legal tools landlords have relied on for over 30 years disappears forever. No warning notices, no quiet exits, no just in case options. Section 21, the no fault evictions, will be abolished. That means landlords will no longer be able to simply ask a tenant to leave without giving a legally valid reason. If you've been thinking about serving a Section 21 notice, you only have a few months left to do it lawfully. Miss that deadline and your options change permanently. If you find this kind of video useful, do me a favour, hit that subscribe button. Now let's get into it. For decades, Section 21 has acted as a safety net for landlords. It allowed you to regain possession of your property with 2 months' notice, without having to justify your decision. That safety net is about to disappear. From the 1st of May 2026, Section 21 will no longer exist. Every landlord will have to rely on Section 8 possession grounds instead. That includes situations like rent arrears, antisocial behaviour, selling the property, carrying out major refurbishments, or moving in yourself or a close family member. In this video, I'm going to break down whether you should serve a Section 21 before the deadline, the risks if you wait, real-world scenarios landlords are facing right now, and what your alternatives are if you miss the window. By the end of this video, you'll know exactly where you stand legally and how to protect your investment. The problem: Section 21 is going away. Let's start with the fundamentals, because this is where a lot of landlords get caught out. Section 21 has traditionally been the simplest way to regain possession, but the Renters' Rights Act removes that option entirely. From the 1st of May 2026, landlords will no longer be able to serve a new Section 21 notice. Any Section 21 notices served before that date will remain valid until it expires or when the tenant leaves, which means notices issued now can still be relied upon months later. This change applies to assured short-hold tenancies in the private rented sector. Social housing follows a different legal framework. At the same time, fixed-term tenancies will effectively disappear and be replaced with assured periodic tenancies, meaning there is no natural end date anymore. A tenancy will only end if the tenant chooses to leave, or if the landlord successfully proves a Section 8 ground. This means that after May 2026, landlords lose the ability to exit a tenancy naturally. Every possession claim will require a reason, evidence, and potentially a court hearing. That's why timing matters. Should you serve a Section 21 now? So, the big question landlords are asking is whether they should be serving a Section 21 before the Renters' Rights Act comes into force. This is not an emotional decision, and it's not about panic. It's about risk management. When serving a Section 21 makes sense. If you have any existing concerns about a tenancy, serving a Section 21 now may be the sensible and strategic option. This includes situations where the relationship with the tenant has become strained over time, where rent is frequently late, even if it is eventually paid, or where there have been ongoing disagreements about repairs, access, or compliance. It also includes cases where the property is not being looked after properly, communication has deteriorated, or interactions have become confrontational. These are exactly the type of tenancies that often escalate into serious problems later. Once Section 21 is abolished, you will have no natural exit route. You will be forced to rely on Section 8 grounds, which means proving fault, gathering evidence, attending court, and potentially facing long delays and significant legal costs. If you can already see warning signs today, waiting until after May 2026 could leave you trapped in a much worse position. Serving a Section 21 now preserves control. You may never need to rely on it, but once the law changes, that option is gone forever. When serving a Section 21 is unnecessary and counterproductive. On the other hand, if you have a strong professional tenancy, there may be no benefit in serving a Section 21 at all. Good tenants are those who consistently pay rent on time, look after the property, communicate clearly and reasonably, and cause no issue with neighbours or compliance. In these situations, serving a Section 21 can actually create problems where none exist. It can destroy trust, push reliable tenants to leave unnecessarily, increase void periods, and create reletting costs that could have been avoided. The new system will still allow landlords to regain possession where genuinely required, such as selling the property or moving in themselves. Good tenants should not be treated as a risk to preempt. This is about risk management, not panic. This is not about mass evictions or scaring tenants. It's about landlords making informed, calculated decisions before their legal options narrow. Ask yourself whether you would be comfortable relying solely on Section 8 if the tenancy deteriorates after May 2026. Ask whether you have strong documentation if things go wrong, and whether you could financially withstand a long eviction process if required. If the answer is no, serving now may be the responsible decision. If the tenancy is solid and low risk, there's no urgency. The key takeaway for landlords: this is not a one-size-fits-all situation. If the tenancy is high risk or already problematic, serving a Section 21 now protects your position. If the tenant is reliable and the tenancy is stable, there's no reason to issue one. The biggest mistake landlords will make is either panicking or doing nothing without thinking. The smart approach is reviewing each tenancy individually before the law removes the option entirely. Real life scenarios. Let's look at some realistic situations landlords are dealing with right now. In the first scenario, a landlord plans to sell a London property within the next year. The tenant is on a rolling AST. Serving a Section 21 now allows the landlord to plan the sale confidently. Waiting until after May 2026 means relying on a Section 8 selling grounds, which can be challenged and delayed. In another case, a landlord intends to carry out major refurbishments. The tenant is cooperative but has no plans to leave. Serving a Section 21 before the deadline ensures vacant possession for the project. Waiting removes the certainty. Finally, there are landlords who avoid serving a Section 21 because they fear upsetting tenants. But once Section 21 is gone, relying on Section 8 for issues like antisocial behaviour or intermittent rent arrears can be slow, stressful and expensive. These examples show that timing and planning are crucial. Alternatives to Section 21. If you miss the Section 21 window, you are not powerless, but your options become more complex. After May 2026, all possession claims must go through Section 8. That includes cases involving rent arrears, antisocial behaviour, selling the property, moving in yourself or a close family member, or carrying out major refurbishments. Section 8 requires evidence, documentation, and often court involvement. Timing can stretch to 3 to 6 months if you're lucky, or more if it's contested. Legal advice becomes essential. It works, but it's slower and far less flexible than Section 21 ever was. Strategy: should you serve or wait? To decide what to do, ask yourself a few key questions. Do you want flexibility? If yes, serving before May preserves that option. Is all your paperwork correct? If not, fix it immediately. Is the tenant low risk and cooperative? You may decide to wait. Are you planning to sell, refurbish, or restructure your portfolio? Serving early may be the safer route. Every month that passes reduces your options. Once Section 21 is gone, it's gone permanently. Checklist for serving Section 21. Before serving a Section 21, make sure your deposit was protected within 30 days and the prescribed information was served. Ensure your gas safety certificate, EPC and how to rent guide were provided correctly. Confirm the notice period is accurate and the tenancy agreement is up to date. Missing even one requirement can invalidate the notice and cost you months. Key takeaways. Section 21 will be abolished on the 1st of May 2026. Notices served before that date remain valid. After that, landlords must rely entirely on Section 8, which is slower and more complex. Planning ahead is essential to protect your position and avoid being forced into difficult situations later. Have you already served a Section 21, or are you still weighing up your options before the May 2026 deadline? Drop your thoughts and questions in the comments. Your experiences could help other landlords avoid costly mistakes. If you found this video useful, hit that like and subscribe button. I'll catch you on the next one.